Okay, let's get started. Thanks everybody for coming so early in the morning. This is the 40th anniversary CSUN Digital Accessibility Legal Update. And I have been coming to CSUN for 25 years and have done this legal update often. So I'm really glad to be back at CSUN, and thank you all for being here this morning. On the title slide, probably the 5 most important words are accessibility is a civil right. This is why we have a legal session at a tech conference. Accessibility, digital accessibility is a civil right of people with disabilities. So if you have to leave now, that's the important message. So, okay. My name is Lainey Feingold. Up on the title slide, I have my website, which is lflegal.com, lflegal.com. I write a lot about the digital accessibility legal space. I am a disability rights lawyer, have been in the digital accessibility world since 1995. Thus, my gray to white hair is my most salient visual feature. I'm a white woman. Because it shows that I've been in it for a long time. I try to write, there's a lot happening. Is there a lot happening? Yes, there is. There's a really lot happening. I try to put what I can on my website, but I don't have a staff. I do everything myself. So I can't put everything on, but when I can't, I try to put the important legal stuff that comes up on LinkedIn and on Blue Sky. So I'm the only Lainey Feingold there. You spell my name Lainey, last name Feingold, Feingold. Last night when I was going over the slides, I realized I didn't have the date. So I put the date, today is March 13, 2025, because things are happening fast. Things are changing fast in the United States. We're in a period of great chaos in the legal space and elsewhere. So this is going to be recorded. It will be available on YouTube either later today or tomorrow. So I really want to make sure I had the date up there. And also, there is no legal advice in this talk. I am a lawyer. I will talk about the law, but there's no legal advice. And last thing to say about the title slide and many of the other slides you'll see, the slides are blue. My accent color is celery. I have a wonderful web developer Natalie McLeese. And the slide deck, she made the template. It matches the website. And on some of the slides, you'll see dolphins jumping in the background. So dolphins are kind of my, spirit animal icon, because I have practiced law for 30 years in this space, and I really have found success in not being a shark. And which makes me think by that response that some of you haven't heard that before, which is wonderful. I really want to, how many people are here for the first time at CSUN? Wow, thank you, thank you. And how many people are here longer than me who started in 2000? Okay, Susan Mazrui up in the front, Shilpi Kapoor, excellent. So we're building a community right here for the next hour of people, first-timers, and people who've been here for a long time. So I thank you for that. I have a lot of content, and I thank the interpreters and the CART person for keeping up with me. It will be recorded, and okay, so I've done this talk a lot of times. Usually I just dive into, what's the law? But today I think we need a check-in, because those of us in the United States know that we are in a very dangerous time legally and politically, with a rogue presidency and a runaway situation out of Washington. So I just really want to acknowledge that at the start, because I am feeling, I know many of you are feeling, and I also want to thank the people here from out of the US who have talked to me so far this week saying, we see you, we feel you, we hear you, and, we're watching. So, yeah, this is my picture for the slide of what we are feeling now, which is kind of a Oh. Okay, I'm going to look to the experts to tell me how is that better? Not much. I can how about this, or we'll switch. Okay, we're gonna switch, hold 1 second, we're gonna switch to the. How's that? Whoa. Yeah. Okay. Thank you so much for speaking up about that. It would be very depressing to be done, to have someone say, I wish she had talked louder. I couldn't hear a thing that you said. Okay. Okay, so our image for the check-in is a bucolic green scene. Not that everything was bucolic before, but there is a tornado landing, and there is dark skies, and there's a lightning storm all happening at once. Because myself, as well as many of you, are feeling fear, we're feeling anger, we're feeling uncertainty, pain, frustration and confusion, overwhelm. How many people here are feeling overwhelmed? I think a lot, thank you, because I'm a kind of person who doesn't really ever feel overwhelmed. I'm like, nose to the grindstone, get it done. And it is very overwhelming right now. There's an absence of hope, and there's a feeling of powerlessness. And that is in the room with us in this community today, and also in the room. And what I hope you take away is this picture, there's still clouds, but there's blue sky, because I want to make sure that we leave here understanding that there are strong legal protections for digital accessibility and people with disabilities in this country. There is ongoing strong legal resistance. There are lots of sources of hope and power. There's lots of sources of hope and power, and we're gonna find those. We're gonna find those. It's been a very hard talk. I did this at AXCON. It was hard. I thought, oh, AXCON, just 2 weeks later, CSUN, easy, same thing. No, it's not like that, because I believe in transparency. I can't be Pollyannish. I can't say everything's going to be fine. There's a lot of things to be hopeful about. So we have to be realistic, and we have to find the hope, and we have to know that we have to find our joy. So this is my hard task. I said to someone earlier, I wish it was a juggler, because that would have been a great entree to this talk, because we're juggling. Open your mind to nuance and to things that seem contradictory, and we're going to do it today. Sources of hope and power. I want to give you accurate information, and I want a feeling of community. I want to dedicate this talk today to the federal employees who have been illegally fired. You know, especially Department of Education. So many of us are involved in education here, and yesterday, as you know, there were, close to 1,500 firings. And just to emphasize the nuance, I was going to start with that. I decided last night, after the Department of Ed firings, I'm going to start with dedicating it to the Department of Ed and the federal employees. And then this morning, I wake up to this in the New York Times, March 13, which is today, right? At 9:31 a.m., half an hour before this talk, a coalition of 21 Democratic attorney generals have sued the Trump administration on Thursday, today, 2 days after the Ed Department fired more than 1,300 workers, purging people, etc. Already the lawsuit is on file. 2 days later, 21 blue state Democrats. So this also gives you a taste of what it's like to do this talk. I have to be on top of the news all the time. So I'm really glad to do this talk, and I will be very glad to not have to pay such close attention in the coming weeks until the next time. So, okay. So what's today's roadmap? I usually like to use a pretty picture of the road. We're in Southern California. I would have had a beach. I would have had palm trees. No, I would have had Route 1. No, I have a very bumpy road for our roadmap picture. We don't really know where it's going. It's not even paved. It's very unknown in some ways. It's bumpy. It's, rutted. But there's a truck on the top who's going to make it through. And that's my roadmap image. What do I want to talk about today? What is digital accessibility? Which I know many of us, all of us know, but if this is a law talk, and if we only think about digital accessibility as a legal requirement, we're going to be stuck in this rutted road. So we need to have the big picture meaning of what is digital accessibility, why we're in the work. We'll talk about that. What is the United States Accessibility Framework? What are the remedies for legal violation? How do we stay current? What are the enforcement strategies? What are the resources? And throughout it all, I'm going to talk about the risks that we face with this administration, and I'm going to talk about our power sources of hope. So when you see the cookies, which I just put up on the slide, these are the accessibility cookies. When you see that, that's going to be the sign that we're going to talk about the power source of hope. Because accessibility is delicious. If you don't know my article on that, on my website, lflegal.com, lots of food analogies for accessibility. And just recently, like a couple weeks ago, someone sent me a note. I had a broken link on one of the recipes for accessibility. And I said, well, I wrote it first in 2018, and then I update it whenever somebody sends me a new analogy, which I invite. And I said, why, what made you look at it right now? Because I chased down the broken link, I fixed it. And he said, we need goodness now. I want to read about food. I want to read about why, you don't put the blueberries in the muffin after the muffin is baked. And that's a symbol for accessibility. I want to read about the melting ice cream cone, because accessibility is like ice cream. If you wait too long, it gets really messy. So I invite you to check out the article, and when you see the cookies, that's where we're going to talk about hope. Okay, what is digital accessibility? My definition, big definition, is it's the engine of disability inclusion in tech. I forgot they gave me this really nice so-called confidence monitor, so I can see the slides here. Okay. We have a great tech team here at CSUN, so I just want to give a shout out to all the support. Today we have Mike and Rick, who's helped me for years here, Mike, who I just met, and we have the sign language interpreters and the CARP people, and Diane Lainey of the CSUN team, who organized all the feature presentations. So nothing ever happens on your own. Engine of disability inclusion in tech, it's a difference between inclusion and exclusion for disabled people. And I always like to start with that, because whatever your role, it gets tedious. It feels like, oh my God, am I really going to have to correct another alt text? Am I really going to have to track down someone who didn't put headings in? Am I really going to teach someone what accessibility is? But everything we do, whatever role we have, we are creating the difference between inclusion and exclusion. So thank you for whatever role you have. And it's the intentional practices that make it happen. Accessibility is privacy, it's security, it's so many other things. I used to say accessibility is like privacy, because, don't we wish that companies, organizations, the government would treat accessibility with the seriousness of privacy. But in fact, accessibility is privacy, because if systems are designed for independent use and people with disabilities can't use them, security is broken, privacy is compromised. So digital accessibility is security and privacy. I like this picture of a very closed up door. It looks like it hasn't been open forever. Paint's peeling, double locks, and then the door opens and the light comes through. And I know it's hard to, it sounds like, oh, really? Door locked, door open, light comes through, but that's what we're doing. And we got to keep the big picture, especially in these times. So I consider all of us, myself and everyone in this room, a door opener, opening the door so people with disabilities can be part of the digital world in 2025. Digital accessibility is a bridge to everything. I have a nice bridge picture from India, very high. All people with disabilities on one side, all of our technology on the other. The accessibility is the connection. Not just web, not just mobile, kiosks, learning systems, all that. So you're not just a door opener, you're a bridge builder. And digital accessibility is a civil right and a human right, like I said before. The picture here is of the Capitol Crawl, which was a activist march where people who use mobility devices, wheelchairs, scooters, canes, left them at the bottom of the Capitol and crawled up to the top to convince Congress to pass the Americans with Disabilities Act. And I like to put, and maybe I should have known this before, but another thing I had to add this morning was that yesterday was the 50th anniversary of the Capitol Crawl on March 12th, 1990. So I swapped out my picture of a protest march leading up to the ADA with this picture of the Capitol Crawl. Maybe you can see or not. It's copyright Tom Olin, who is a movement photographer during the ADA, and I purchased some of his pictures for my talk. So I say that in the law thing because sometimes law, you feel, oh my God, the legal department wants me to do this, or there's a checklist, or there's some requirement. But these laws did not fall from your legal departments. They did not fall from Congress. They came after advocacy and blood, sweat, tears, years of organizing and writing and planning and building community by the disability community. So that's why I like to start with a picture like this so we don't forget. We're talking about the Law at a Tech conference as a result of the work of disabled people, and that is our mission, to continue that work in the work that we're doing. So why is it a civil right or human right? Because without accessibility, there's no participation, inclusion, communication, everything, education, whatever your role. I wish we had 3 hours, because then I could, say, well, what do you do? Where are people locked out if you don't do your job well? And where are people locked out if you don't do your job well? So health and safety and all those other things. So those rights, civil rights, human rights, those big ideas, opening doors, building bridges, those are baked into laws, which is why I have my raw chocolate chip cookie dough picture. Probably not that good for first thing in the morning, because I didn't have time for breakfast before I came here. The cookie dough is still raw. It's not the cookies, because without implementation of the laws, we have raw cookie dough, but the laws incorporate these big ideas in these civil rights. So what is the digital accessibility legal framework that we're going to talk about next is the framework in the United States. So these are several components. They work, I have a picture of like gears. They each work separately, but they all work together. We have federal laws, apply all across the country. We have federal regulations that are based on the federal laws. We have federal agency policy statements. Those 3 are the biggest things at risk right now. We'll talk about that. But we also have state laws, and we have local laws. How many of you know that you live in a state that has either an accessibility or a disability rights law? A lot. So let's, why don't you clap? Not everybody can see the hands, so I can, yeah. So we'll talk about the state laws, but don't forget, Trump and Musk don't run the states. So, yes, I'll tell you what, these 21 Democratic attorney generals who have already filed lawsuits, they run 21 of those states, so let's not forget that. And we have global laws impacting the United States, and throughout it all, we have implementation and enforcement. So that is the framework. The first part of the framework is the US, federal laws, regulations, agency actions. So now we're going to talk about existing laws and regulations that exist today. There may be a risk in the future, but today they exist. Of course, we have the Americans with Disabilities Act since 1990. 2 parts of the Americans with Disabilities Act that bring in digital is the fact that there's no discrimination allowed, and covered entities like schools, colleges, businesses, public sector have to effectively communicate with students, with the public, with employees. That is why, since 1990, the ADA has required that. Since 1990, it's been no discrimination, and you must effectively communicate. If you do not have an accessible website, the content cannot be effectively communicated. And that's why, ever since 1996, the Department of Justice recognized that the ADA, passed in 1990, when there was not a web. Hopefully that's a true statement. I know someone in this audience will correct me if I'm wrong. In 1996, and I have to read this. Like, we're not just in a time of chaos where things are changing. We're standing on history. We're standing on a really deep history. In 1996, the Department of Justice got a question from a senator who asked, what about the accessibility of, quote, web pages on the internet? I love that. It's like what's so new, they had to put it in quote. What about accessibility of web pages? And the Department of Justice said, and this is September 9, 1996, good reminder to silence your phones, please, or your watches, or whatever digital device you have. Covered entities under the ADA are required to provide effective communication, regardless of whether they generally communicate through print media, audio media, or computerized media such as the internet. I just love that. And, we'll talk about the risk, but it's not easy. That cannot be dismantled in an executive order. I just want to say that right here, even though we're going to get to the executive orders in a minute. That's, 30, yeah. Okay, so digital accessibility since 1996, and last year the most recent thing is the web and mobile rule. We'll talk about that in a second. We have Section 504, which basically says if you're going to take money from the federal government, you can't discriminate. Section 508, which says if you're going to sell to the federal government, you have to be accessible. The federal government has to have accessible tools for the federal workforce, such as it is. No. We have the Communication Video Accessibility Act. We have FCC regulations under that. The CVAA is primarily about captioning, audio description, services for blind people, deaf-blind people. Air Carriers Access Act, which has rules about kiosks and airline accessibility websites. And the Affordable Care Act, Section 1557. And we have laws not related to disability rights that are being used to advance accessibility. So we're going to talk all about that when we talk about enforcement. I have a map here of the United States. It's colored into 13 sections because the court system is such that even though these laws apply everywhere, they can be interpreted differently in different courts. So we don't have time to dive into how courts interpret things differently, but I just want to urge you, you see on LinkedIn, every time there's a case against accessibility, it's like, oh my God, some judge said you have to have a physical place or whatever. But it's really important, there could be another judge somewhere who's saying something else. And you're not designing your products and services for one district court in New York or one district court in Florida. You have a website, you have a mobile app, it's being used everywhere. So it's important to know that there are different interpretations, but not important enough to slide into this talk where I'm already running out of time. Okay, so the new ADA web and mobile rule. Again, all those laws on the previous page, those are laws now. Those are laws today. Section, lost track. Oh, here we go. Okay, the new ADA web. I can do it without notes, but I really couldn't do it without the slides. Okay, the web and mobile rule, many of you are affected by. It's state and local government only. I have some pictures. It's not just the state office in your state capital. It's the libraries, the jails, the parks, the universities, anything publicly funded in the states. The standard is the Web Content Accessibility Guidelines 2.1 AA. The time frame, it's going to kick in next year or the year after, depending on the size of your organization. But it's really important to note that the ADA is not suspended. The ADA is still there. And I do, for a little bit of history that we're standing on, this thing here, accessibility of state and local government websites to people with disabilities, 2003 from the US Department of Justice. 2003. So this has been baked into the Americans with Disabilities Act since before 2003, but that is from 2003. So the ADA isn't suspended. There is a case in Louisiana where a blind person sued the state of Louisiana, this is within the last 6 months, and said, your website's not accessible. State of Louisiana said to the court, well, it's not 2026 or 2027. We don't have to do it yet. And you should throw this case out of court. They can come back in 26 or 27. And the judge said no, that these regulations provided technical standards, but the ADA has required non-discrimination and effective communication since the beginning. So it's really important to remember that. I have an article on my website, lflegal.com. If you search Louisiana, it's the first thing that comes up. I was surprised there were 6 other things that came up too, but this case is the first. We don't have time to delve into the WCAG, but there's 2 really good resources. The Department of Justice left us a gift, the Biden-Harris Department. There's a fact sheet and there's a video. The video website is ada.gov/title-2 in little Roman numerals -web rule. But if you put into the search engine Department of Justice, Web and Mobile Access Rule, fact sheet, these are going to come up first. I checked them this morning, they're still online. So I recommend looking at those, downloading them, because the information is good. Okay, so those are the existing laws. What is the risk to the existing laws and regs? Whenever I show a risk, I have a picture of a Scrabble tile holder. It says risk. Not that creative, but there's a lot of risk. So, okay, people ask, will the ADA change? Will the ADA regulations change? I did a talk, someone said, well, what does your crystal ball say about this, that, or the other thing? And I'm like, my crystal ball is very cloudy right now because, I don't think, okay, first of all, for the ADA to change, they can't do it with a stroke of a pen. They can't do it out of the Office of Personnel Management, which is issuing all these terrible things. They can't even do it out of the Department of Justice. It has to be out of Congress. I know there are still some people that think the ADA is a bipartisan, the disability issues are bipartisan in the United States. That was definitely true in the past. A Republican president signed the ADA in 1990. Personally, I don't think bipartisanship is alive and well in the United States right now, but I don't know what to say. I think it would be very hard to change the ADA. The one thing that, just in case you go back, well, why didn't you mention this? For the last 5 years, they've tried to change the ADA in Congress so that disabled people don't have the right to sue directly without giving notice and having certain requirements. So disability community is very opposed to that. No other kind of discrimination law has a requirement like that. Maybe something like that could change, but otherwise I don't really see the ADA changing. I don't really see the regulations change. Again, the regulations can't be changed with a stroke of a pen, can't be changed with a memo. The regulations can change because the Department of Justice could issue a new regulation, something we don't like, something negative, something that changes the dates of the Title II web rule. I don't think they will. They have so many, one of my favorite quotes from Kamala Harris was, if I get into the White House, I'm going to come in with a to-do list, and if he gets in, he's going to come in with an enemies list, which was music to my heart because I'm a big to-do list person, but also it's so sad how true that proved. And he has so many enemies, and it's hard to believe the web regulations are going to be high on the list to make a change, but could happen. Yesterday or the day before, the Environmental Protection Agency announced that it's getting rid of almost all environmental protection rules. He made a speech and he said it's going to happen. It can't happen from a speech. Even the New York Times said, for this to happen, they have to go through rulemaking. They have to give a notice of proposed rulemaking. There has to be public comments. It's not that it can't be done. It's not like someone can't come in and say, okay, we're not going to have any ADA rules anymore. I just don't see it happening, but it would be disingenuous to say it couldn't, given that they just erased 50 years of environmental protection in a press release. Or didn't erase, tried to erase. There can be private lawsuits. These are the risks. It can be private lawsuits challenging our laws that exist today. One of those is currently existing. How many of you are aware that there's a lawsuit pending in Texas to declare Section 504 unconstitutional? Yeah, not all of you. So thanks you to those paying attention. It's hard to pay attention to all this, so I don't judge anyone for not wanting to know. So I'm not suggesting you need to know. But yeah, there is a law pending. There's a lawsuit pending. There's a lot of conservative lawyers out there who think it's a field day to attack things they don't like. And Section 504, which was a law that was part of Crip Camp, is been around for 50 years, like I said. Sorry, I didn't hear. Yeah, I think you said since 1973, Section 504, and there was a big demonstration and a sit-in in the federal building, longest sit-in ever in U.S. history. Again, we have these laws, we have the regulations because of the work of our foremothers and forefathers who came before us in the disability community and allies. So there's a law. The best way to get information on that is through the website of the Disability Rights Education and Defense Fund. It's dredf.org. They're doing a great job. They update, they have a fact sheet, they have calls to action, they have webinars, and so far the disability community is completely on top of this lawsuit and making sure that it's not successful in declaring Section 504 unconstitutional, but these things can happen. Anyone can file a lawsuit. What can judges do? Judges, Trump already appointed bad judges in 2016. And when I say bad, what I mean is judges with a political bias against rights. They can chip away. We have a Supreme Court that should have a big risk sign on it. They can take away rights. So these are things that can happen. And Congress, like I said, they could change some of these laws. I'm saying the ADA, there's all the whole framework, but I don't think they will. The executive orders. Let me just say quickly about the executive orders. So right at the beginning, he put out the executive orders on DEI, diversity, equity, and inclusion. Some of them refer to DEIA, diversity, equity, inclusion, and accessibility. I have 2 articles on my website written by Eve Hill, who's a disability rights lawyer and used to work at the Department of Justice, analyzing the executive order back in February as to what it meant for accessibility and disability. So I encourage you to look at that. They recently did a slight backtrack on the A part of DEI, DEIA. That's another thing. You read the news, and like the next day, the news changes. So we have to, I don't know what to say. We can't just read the news, and we can't completely react. I mean, we can be sad, we can be angry, but we also need to know, like I said at the beginning, 2 days later, this Department of Ed fiasco has already been challenged. So there was a backtrack on the DEIA, the Office of Professional Management, which is like the HR department for the federal government. They put out a regulation. They put out a memo, which kind of said, oh, we made a mistake. They said, the DEI memo is like, close all your DEI offices, fire all your DEI people, don't do this work. They changed it. They said agencies should not terminate or prohibit accessibility or disability-related accommodations, assistance, or other programs required by laws. And when you're firing people and executing a reduction in force actions regarding employees in the DEIA space, agencies should therefore retain the minimum number of employees necessary to ensure agency compliance with disability and accessibility laws. So I invite you to take a look at the article I wrote about this, because it was very hard and nuanced to write, and I'll just refer you to that instead of going through 3 days it took me to write like a 2-page article, because it's good, they recognized accessibility and disability, but it is bad to be still having a DEI memo. And all this DEI stuff, some people say, well, it's good to take accessibility out. Disabled people are also Black. Disabled people are brown. Disabled people are LGBT. Disabled people are trans. Disabled people are immigrants. So, I usually try to write very, very sort of calmly and factually. And when I wrote that article, I just said I wasn't going to talk about it, but it was just so, I wrote the sentence, it didn't sound like things I usually write, but I felt it so deeply that divide and conquer is a tool of the oppressor. And collaboration and cooperation is a strategy of resistance. And I really feel that way. And I also want to recognize that, yes, it's good. They're not going to fire everyone doing accessibility in the federal government. Thank God for that. So it's very nuanced. My article, I made a bit.ly short link, bit.ly/OPM A11Y. So you can read that. What about new laws? Okay, will there be new laws and regulations? Usually this is sort of a fun part of the talk, and I say, well, this is pending, and this is pending. We're going to strengthen this. Well, the cloud is very dark in this picture. The cloud is very dark because there are pending national laws. They're not laws. They're proposals for new laws. There's the website and software applications law that was going to expand accessibility requirements to the developers. There's an update to the CVAA called the Communication Video Technology Accessibility Act. There's a Section 508 refresh. Those are all on the table before January 20th. I just don't see any possibility of getting any new laws in the next 4 years. I understand the disability community may want to keep advocating for them, keep them on the table, but I wouldn't get the hopes up. And there's other laws that were pending that are already off the table. A lot of attention on a California accessibility bill called California 1757 last year, never passed in California. Self-service kiosks, regulations that I have been working on off and on since 2010. They didn't get finalized, so that's not happening in the next 4 years. EV charging stations. So I'm putting a big red X on will there be new laws. I can't see it. My crystal ball seems clear enough for that. Okay, what power do we have to protect these federal laws? So here come the cookies. We have disability and civil rights lawyers challenging Trump and Musk on everything and winning many things. Most of the lawsuits are in the early stages, asking the courts to say, stop this for now while we have a chance to argue the legal stuff. That's called a temporary restraining order, or TRO. You can track the lawsuits if you go on Google or search engine and say, track lawsuits against Donald Trump. I have some links in my articles you'll find, but you can find them on Google. There's several good sources. There's one called the Civil Rights Clearinghouse. I know the person who does that, and it's really reliable. So that's kind of empowering. If ever, you read something that's terrible, switch to that for a minute and just see that there are not just disability rights lawyers, civil rights lawyers pushing back at every corner, protecting the laws in court, like Dredif is doing in that 504 case. Staying the accessibility course is resistance right now, because even though all those laws are still the laws, they're still the requirements, we have seen some backing away. So if you're with an organization, if you're a decision maker, if you're still doing accessibility, you are part of resisting this chaos that is ensuing. And we are our best hope. This community sticking to the work, doing the work, amidst the swarm and the lightning storm and the tornado. Bipartisan support for ADA, I already said, I don't really buy that. There is a complex process for rule change, so that's a little bit of a cookie. Not that sweet, because you can, at the end, get a bad rule. And we have fair judges, and we have blue state attorney generals. So I started with the 21 Democratic senators who've already filed suit on the Department of Ed. I want to tell you another one, the power of the states to push back against federal lawsuits. So on February 13th, there were, I think maybe 16 or 17 states led by Massachusetts who put out a guidance, which I did the bit.ly link, I called it bit.ly/DEIA truth. They let you put the back end, when you create the short link. And it's my article about this state guidance, and it's all about how DEIA is legal. It's legal. And I just pulled out one quote: employment policies incorporating diversity, equity, inclusion, and accessibility best practice are not only compliant with federal and state law, but they help reduce litigation risk by protecting against discriminatory conduct. So these are states who put out the memo and said, if you're in these states, DEIA is legal. And the truth is, it's legal everywhere. It's just only the blue states did it. So really important. I really recommend that article. It gave me a lot of hope and heart. And I also put an extra piece of cake on it, which comes from that Accessibility is Delicious article. There's a whole thing about layering accessibility. So, okay, the federal government used to do a lot of other things besides regulations and laws. This was great U.S. agency guidance on, from the EEOC, from the Department of Justice, from Health and Human Services, from Department of Education. I illustrated this with a woman, a telehealth pictures, a black medical professional in a white suit and a kind of sad and looks like he has a flu patient, black patient on the screen, because it was great advocacy and guidance. Sometimes they can't get out the regulations, but they really issued a lot of good guidance on telehealth, on AI, on workplace, higher ed. I write about all these on my website. So that guidance defines what the law is. We have different people defining it now, but that doesn't mean it's not useful to us. So the risk, of course, is that we're not going to see any good guidance. I bet we're not. The old guidance could be rescinded. I bet it isn't, might get taken off the website, but I don't think they're going to, say this isn't true anymore. And we could get bad agency guidance. Guidance is a thing federal governments can do. So we can protect ourselves on that score too, because the Wayback Machine has all the old guidance, and the substance of what is deleted can still be useful in your individual advocacy, in a court. I have a website article on my website. If you look for broken links, you can find it, and I explain all this, like why I'm going to try to fix the broken links on my website because I did a lot of referring to government things that are no longer on there, and I'm going to replace it with the way back, but I'm going to leave the old one also so we remember this is not going to last. I do believe this is not going to last forever. I think we're going to just leave it at that. Okay. So this is the framework that we have today, right now. We have it today. So I think I want to leave this part. We're talking about the U.S. framework. This is a federal laws and regulations part. I want to leave it with this idea: don't obey in advance. Don't obey in advance. Yeah. Yeah. So this is from a book by a Yale history professor that he didn't write just now. His name is Timothy Snyder. It's called On Tyranny. It's about how autocratic governments take hold. This is our risk right now, and what individual people can do. And one of the ways they take hold is by people thinking, oh, well, they might come after me for DEIA. I don't want to do it anymore. And they will. You know, they're already investigating some companies and some schools, but as much as we cannot obey in advance, that is an act of resistance. Just keep doing what we're doing until someone actually takes that computer out of our hands and says, you can't do this anymore. So, and I'm really glad to share this on this slide because a few people have said to me, oh, that's a great quote. Can I quote you on that? I'm like, no. I'm lucky that somebody else first put this out, in the fall. So Timothy Snyder on tyranny. Okay, the second part of the framework is the U.S. states and other countries. I have a map of the United States, all different colors. States have different colors. States have different laws. So many states have anti-discrimination laws, just like the ADA. They have state-funded laws, just like 504, that says you're going to take state money. You can't discriminate. You have to be accessible. They have state purchasing laws, like Section 508. There's laws requiring state agencies to be accessible. Maryland has a law about K-12 procurement of tech, that has to be accessible. There's states, growing number of states that have laws about accessible prescriptions. So this is a little counterintuitive, but I have a global law page drop down from my legal update tab. And in the global law page, the United States is listed. Within the United States, I have the federal laws and the state laws. So for the states, some of the leaders are, New York, and Colorado has a great accessibility law and a team. Rhode Island has a new one. But it's not totally up to date. As I said, I have no staff. I have a big to-do list, just like Kamala Harris. But you can see some of those states, and I invite you to not just look at your own state where you are, but if you're working for an organization that operates nationally, you have to be operating to the highest standard of the highest state, because you're not going to have one policy for one state and a different policy for another. So the U.S. state framework, and of course the global framework, we now have companies impacted by the European Accessibility Act. Brandon Johnson's going to do a talk this afternoon on the European Accessibility Act. We have U.S. companies impacted by the Rights of Persons with Disabilities Act in India. Tomorrow, Shilpi Kapoor and I are going to do a talk on legal issues, not in the U.S., not in the European Union. So big task, but anyone who's here on Friday afternoons, welcome to come. And I have the global law and policy page because accessibility is global. So what are the risks to state laws and global laws? Much shorter list. It's true that states could weaken disability laws. I don't really see that happening. I actually see states stepping into the void that's going to be left by the federal government and strengthening laws. So that's a place for advocacy for all of us in our individual states. It's possible there are some states that are limiting the right to sue about digital accessibility. I think Kansas and one other state. I would pay attention to that in your state, and if you can stop it, advocate for that, I would. Some court interpretations could go wrong, but basically the power in state and local law is mostly the cookie, because states can strengthen their laws, new states can adopt laws, the court interpretations can be good, and states, as we see from the this blue state memo around in the blue states filing lawsuits and issuing memos that DEI is legal, they're not affected by the chaos. They're affected, obviously, but they have strong legal departments, they have strong attorney generals, some great attorney generals across the country. So that is one of our biggest hopes. And of course, foreign countries can look at us and say, what are they doing over there? We're not going to pay attention. Okay, today's roadmap. I'm looking at the clock. Let's talk about remedies and enforcement strategies. What happens if the law is ignored? Those are called remedies, which is why I have a picture of a tea bag, remedy for cold. Well, similarly, there's remedies for breaking the law. One is fix barriers and fix systems, and all the different laws that still exist, all the regulations. They don't have all of these, but some have some of them. There can be court agency oversight. There are DOJ penalties written into the Americans with Disabilities Act up to $150,000. We're not going to see any of that in the next 4 years, but it is there on the books. When you get involved in a lawsuit or a collaboration structured negotiation, I think I've been talking so fast I forgot to say that I have been a disability rights lawyer for all this time, but for those who don't know me, instead of doing lawsuits, I have worked in a collaborative process with the blind community primarily, and companies willing to say, no, we're going to be a dolphin, not a shark, and do structured negotiation. So whether you're in a structured negotiation or a lawsuit, you might have to pay the disabled people because some states have a remedy for money. The ADA does not. You have to pay the disability rights lawyers, which is fundamental to my ability and all disability rights lawyers to do this work that Congress realized 50 years ago, before the ADA, that in discrimination cases, people who are discriminated against, women, people of color, disabled people, have a right to have good lawyers who should get paid by the person who did the act that required the lawsuit. So this is what's going to happen. You're going to have to pay lawyers to defend yourself. In the European Accessibility Act, there are fines, even jail. So my thing about remedies is be proactive, not reactive, and fix the barriers in the system. Because you're going to have to do that at the end of a lawsuit. You may as well do it now. Okay, how are laws implemented and enforced? People with disabilities are enforcing these laws every single day. Every time they call your organization and say, I can't find this, I can't see this, I can't use this, that is enforcement of a civil rights law. There's private party lawsuits, there's structured negotiations, which is what I do, and there's covered organizations doing the right thing who are, by doing the right thing, by having their accessibility programs, doing accessibility in a deep, responsible, ethical way, are enforcing the laws. And there's government agencies. I put that last because that's where the risk is. A couple quick things. In years past, even year past, a lot of the enforcement things I reported on were done by the federal government. Under Obama and Biden, we had very good enforcement, also by Department of Ed and other agencies. So I want to just share with you real quick some private enforcement, because the private sector, disabled people and disability rights lawyers are not going away. They are still going to be enforcing the laws. And just some quick example, there's a recent access to health care against University of North Carolina healthcare system, a private lawsuit where one of the hospital paid $150,000, another paid $125,000. There was a 3-year injunction against a hospital. These are things that private lawyers and private people and disability organizations can get from the law. That's not going away. And there was more than $1.2 million in attorney's fees paid by the hospital to the lawyers. I know the lawyers, very ethical, good lawyers, but when the other side fights, there's nothing to do but fight back, and that's why attorney's fees end up being a lot of money. There's a lot of good private enforcement in education, which obviously will be needed given the situation in the Department of Education. The Los Angeles Community College District, there was a $240,000 verdict. Then the judge reduced the verdict. There's earlier settlements against colleges and universities that can be a roadmap, even though they're in the past, for anyone in higher ed. City University of New York, which the Department of Justice did. It wasn't private, but it's still a roadmap. UC Berkeley, Harvard, MIT, Miami University in Ohio. And I just want to say, when I mention a lawsuit, and I'll just pull out Harvard as an example, sometimes organizations, schools, colleges, they do the wrong thing. They get a lawsuit. They take that as an opportunity to build a damn good accessibility program. And Harvard's a good example of that. So I always like to say that the accessibility work that is being done there is very strong, and has national leadership. And I like to say that because you feel, oh, they're a bad company because they got sued. So that's true for many of these organizations. They get sued, but they take it as an opportunity to improve. And then the private lawsuit website numbers. Many of you know I don't really like many of the private web accessibility lawsuits for various reasons, but in these times, I must share the numbers. There were 4,224 lawsuits filed last year against organizations because their websites were not accessible. 961 were against defendants already sued. 99% were about websites. We could have a whole talk about why that is. And 1,023 were against companies using an overlay. So those are private sector. Those are private lawyers filing private lawsuits under laws that exist today. Beyond websites, there's a lot of private party enforcement in kiosks, and there's been a case about VR captioning by a private person. These have all been successful. I'm going to put these slides up. I know I'm going fast. I'm going to put the slides on my website when I get home next week, because I noticed people taking pictures, and I do want to share them, so I know I'm skipping over some of the details. Podcast transcripts is a lawsuit pending for a long time now about requiring transcripts on podcasts. And I have articles about all those kiosk cases and all the podcasts, all those cases on my website. Okay, using other laws to enforce disability and accessibility rights. This is kind of exciting to me because these are laws that have existed forever separate from disability. So there's a law called the False Claims Act. It's a federal law that says, you know what? If you're going to sell something to the federal government, many states have them, if you're going to sell something to a state government, you can't make a false claim about it. You have to be truthful. And that has been used in a case in California against a park service because they ordered a website, and the website had a contract. It was supposed to be accessible, and it wasn't. They made a false claim about the accessibility. So a lawsuit was filed by an individual private lawyer, a private disabled person, to sue, and it was a very successful suit. They recovered the money for the state of California that had paid out for it, which this case is we could do a whole hour on this, a whole call out to make sure your procurement is accessible. Don't buy broken things because the best laid plans can be ruined by taking in things. Another one is using unfair dealing laws against overlay companies. And this is also good because every state has laws that say you got to be honest in business. You got to treat people fairly. You can't lie in your advertisement. So there's two cases about that, one against Accessibility, one against UserWay. I've written about both of them on my website. These are small businesses suing the overlay company because they didn't feel they got what they paid for. There's also the Federal Trade Commission action about overlays. You can look on my website under FTC, where they agreed with Accessibility would pay $1 million fine. That has to be finalized under the Trump FTC, so we don't know what's going to happen to that. Okay, the risks to legal remedies, of course, is enforcement by the government. Those are our biggest risks. The Department of Ed yesterday, as I said, they fired 1,315 employees. They closed half the offices. They got rid of nearly 50% of the office of the workforce, 60% of the lawyers. Hard to believe there's going to be complaint investigation, and they put up a new website called enddei.ed.gov, which is solely for people to report. It's like McCarthyism, to report when they think their state or their school system is doing something that they think is illegal DEI, i.e. Black history or trans history or LGBT history. So our biggest risk is the lack of enforcement. I have an article on my website about the Department of Ed saying last month that, oh, well, we're not going to handle any complaints anymore. They had 10,000 backlog of complaints left over from the Biden administration. We're not going to handle any of them. Well, no, we're going to handle the disability ones, but not the race and gender ones. And I have an article, same thing as the other Office of Professional Management. This idea of dividing and conquering, I don't think is a path forward. Department of Justice, same thing. They've been great allies, the U.S. attorneys. They've done amazing work, many articles on my website about it. I can't imagine enforcement by the Department of Justice on the issues we care about. But where's the power? The power is in the private enforcement, the state enforcement. The New York Attorney General was doing cases as far back as 2009 about web accessibility in New York companies. I have an article about that on my website. So we can count on the private lawyers. We can count on the disability community. We can count on organizations still doing the right thing. And we can count on disability community advocacy. I'm going to skip this one. How do I stay current? You can stay current the same way. I like the agency email list. Well, I doubt I'm going to, if they still have the list, I'm probably not going to like what they send. So I'm not recommending that. I have the social media, like I said. The Safe Arth Shaw has a blog. Equal Entry does a podcast that often covers legal issues. Converge Accessibility covers legal issues. And Accessibility in the News covers legal issues. So I want to close with this. Quote from Lucy Greco, who's sitting in the front row here. Being in accessibility can be soul-crushing. It's positive things and success stories about our work that keeps us going. And this is a time where we need to share those stories. I don't care how small they are. We need to celebrate the victories. We need to be as public as we can to give this community and all of you watching and the global accessibility community the hope we need at this time. And we need to take care of ourselves. So my last two words, one is joy. I have actually written a digital accessibility joy plan. You can see I changed this first thing in the morning because it said digital accessibility joy play. So I said, oh no, it's a typo. I have to say digital accessibility joy plan, but I forgot the N. I apologize. Yeah, play would have been good, but now it just says pla. Anyways, I got that idea from a professor who teaches a graduate course on Journey to Joy. We can control our joy in the midst of this. Doesn't mean we're going to be happy and lighting up balloons, but we're going to do the things that ground us back to why we're in this in the first place. And so my digital accessibility joy plan includes things like, remember, we are part of this community. And that is my last word. So that's what I got. Yeah. I see some people standing, and I'm back to you. It's all of us. Thank you. Yeah. I mean, as you know, I'm a disability rights lawyer. Being embraced by this community all those many years ago and all the way since has truly been one of the biggest joys and honor of my life. So for everyone standing and clapping, right back at you. Let's just, keep doing it. Don't obey in advance. Find our joy and enjoy the rest of the conference. Thank you.